Welcome everybody. Today in our oil and gas class, we are moving from the segment of the course that was about the lease, in which we covered a lot of different interpretive issues that happen with the lease, to some of the interpretive issues that arise when you're transferring other oil and gas interests, when you're transferring a mineral interest or a royalty interest. And we've talked about those before, so you remember. And here in today's readings, you had a reading about the ability of the landowner to sell his or her mineral interest to somebody else, even while retaining the surface interest. And similarly, we've talked about royalty interest. So just as a reminder, we've been talking for weeks about the lessor's royalty, that royalty that's reserved from the lease by the lessor landowner. That's their primary compensation for granting the lease to an oil and gas company that will be able to keep the bulk of the oil and gas that's produced. But we've talked about other kinds of royalties that can be given. One is that overriding royalty that's granted out of the leasehold interest by the lessee, the oil and gas company. But starting today, we're going to start talking a lot more about non-participating royalties. So that is a royalty that's created by the landowner that says, here, somebody, you get a 1/100th share of all the oil that's produced from this land. That is a royalty. It's a share of everything that's produced. You're not worried about what it costs to produce it, etc. But it's not through the lease. It's just given by the mineral owner to burden that mineral interest. And we'll talk about some of the different kinds of royalties as we talk about the interpretive issues that arise when you grant either a mineral interest or a royalty interest or something that maybe looks in between. And so we'll talk about that. Okay, so as you're interpreting these grants of a royalty or a mineral interest, we see that there's some common interpretive steps. The first step is we look at the plain meaning from the four corners of the instrument. Do they make clear we're granting a royalty or we're granting a mineral interest? And then we use some rules of construction. Sometimes we use, like the largest estate, the idea that the grantor gives the largest estate possible. Sometimes we say that we're going to construe the instrument against the drafter. Sometimes we say that specific terms govern general terms. Sometimes we say handwritten parts. Those were the parts they obviously were thinking about most carefully. And then if all else fails, we'll look to extrinsic evidence that goes beyond the actual contract. That's very rare. So let's talk about a first quite complicated case, this McSwine versus Musselshell County case from Montana, 1981. It's on page 459 of your books. So what happened in this case is the county sells some land, but it reserves something for itself. So we know that those are the two ways, basically, that a mineral interest gets separated from the rest of the land, the rest of that fee interest. One is there's a grant of a mineral interest to somebody while retaining the surface. And the other is that there is a grant of everything in the property except for the mineral interest, which is reserved. So in this 1933 contract, the county reserved to itself an undivided 2.5% of all oil and gas and other minerals lying in, under, and beneath the premises. So basically the surface and 97.5% of the minerals go to the purchaser, but the county reserves to itself 2.5%, a 1/40th share of the minerals. Okay, we'll see it gets more complicated because there's a 1943 decree that says when the county gave this to Shields, Shields owns that full property, accepting and reserving to the county 2.5% of all oil, gas, or other minerals lying in, under, and beneath. That's fine because it's very similar to that 1933 contract. It's basically a 1/40th share of all the minerals. Where it gets complicated is with this 1944 deed that, again, same property, but it says that the county is reserving an undivided 2.5% royalty of all oil, gas, and other minerals lying in and that may be produced from the premises, delivered free of cost. Okay, so what's the problem here? Well, before it sounded like a mineral interest, 2.5% of all the minerals on that land. But in this 1944 deed, it says a 2.5% royalty. So that sounds different. That's a 2.5% share of what's produced from that land. Now, you could start to think about which of those interests you would rather have, but that is what turns out to be a central question in the case. Because what happens is 30 years pass, Shields, the landowner who purchased most of it, leases to Exeter. Well and good. But the county issues oil and gas leases to McSwine. So it gives leases to McSwine, but it says it reserves the right to contend that its interest is a royalty. Okay, that's confusing. So if what you get is just a share of the oil and gas produced, you can't really lease that. That's just a share of oil and gas. So if they had a royalty, which is what the 1944 deed said, then they wouldn't be able to lease it. But they basically say, well, maybe we have a mineral interest, maybe we have a royalty interest. If it's a mineral interest, we're leasing it to McSwine. So McSwine says, okay, I've got to figure out what I have here. Is this a valid lease? Did they really have a mineral interest? And did they really lease that 2.5% mineral interest to me? Now note, this is technically possible. So as we'll see in future cases, sometimes a mineral interest is fractionated between several parties, and different oil and gas companies will lease those different fractions. And then they have to figure out how to operate together. They can do that through a joint operating agreement. That how those work in specific is really the subject of a couple other courses that we offer here at SMU, including Advanced Oil and Gas Contracts, which is with Professor Lowe. And you can see it's actually in some of the later chapters in your book. But basic question is, okay, what is going on here? Was it a 2.5% mineral interest or a 2.5% royalty? And so were these leases to McSwine valid? The district court says the mineral interest was more valuable than a royalty. And remember, the first two things in 1933 and 1943 made it sound like a 2.5% mineral interest. And so the court says that later deed that makes it sound like a royalty would be an unconstitutional giveaway, because basically the state has a rule that the government can't just give away its interest in return for nothing. And so the suggestion from 43 to 44, and I can go back and show you that, but the suggestion that it turned from a mineral interest to a royalty interest would be unconstitutional, because that would be an unconstitutional giveaway. So therefore, it's still a mineral interest, and therefore the leases are valid. Okay. Now, why is the district court saying that 1933 and 1943 mineral interest is more valuable than the royalty? Well, because as we discussed, you can't lease out a royalty. That's just a share of the oil and gas produced. It doesn't come with the right to lease. But maybe you can start to see, maybe you might have some doubts already about that district court decision, and we'll talk about why. But the district court says it's a mineral interest. You can't switch it to a royalty. That would be the state making its interest less, giving it away. And so it's a mineral interest. These leases are valid. All right. What happens with the appellate court here? Appellate court says, no. A mineral interest is not necessarily better than a royalty interest. So remember, the two options are that we have a 2.5% mineral interest and a 2.5% royalty. Now, which of those would you rather have? Okay, it's true that if you have the mineral interest, you can lease it out to somebody because you have control of 2.5% of the minerals. You can figure out how to lease it. But on the flip side, how much are you going to get for that lease? Well, normally you get a 1/8 royalty, particularly back around the middle of the 20th century when this lease was granted. So if you have 100% mineral interest, you get 1/8 of all the production that happens on this land. If you have a 2.5% mineral interest, you get 1/8 of 2.5% of the production. So you really get much less than 2.5% of the overall production. By contrast, if you have a royalty for 2.5%, 1/40th, you get that full 1/40th of production. So the royalty, it doesn't give you the power to lease it. And we'll talk about that power to lease. We've previewed this before, but we'll talk much more about it in future classes. Is called the executive right. Yes, you don't have the executive right, but you actually get more oil. So if what you want is money, the royalty is actually better. So the court says the royalty might really be better here. In reality, it usually is. And so they say it was fine to, from 1943 to 1944, transform it from a mineral interest to a royalty interest. So that means the 1944 deed is okay, and thus, as a result, the leases are no good, because if what they have is a royalty, you can't lease that to McSwan. So the court says, look, yes, the mineral interest is conceptually larger, because it says you own 2.5% of the minerals in the ground, and that gives you the right to lease them. But it's not actually as valuable, because you'd rather have 2.5% of the oil and gas that actually hits the surface, because that will give you a bigger share of the money. Also, you might wonder, so in theory, as we said, it's possible for all the different fractionated landowners to lease out those small interests. But in practice, if one owner leases a 97.5% interest and the other owner leases out a 2.5% interest, who's going to have more control over how it's really leased out? So in theory, the mineral interest comes with this ability to choose how your minerals are developed. In practice, as we'll see later, if you have a 2.5% mineral interest, you're not going to have very much choice in how things are produced. All right. So note that there are some other things that you miss out on if you just have a royalty interest. So if you did the 2.5% mineral interest, that means you get 2.5% of any royalty that's paid on the land, but you also get 2.5% of the bonus and delay rentals and shut-in royalties. So you get those other pieces as well. With the royalty, you just get a 2.5% of all production. But again, remember, because the royalty is the main compensation the lessor receives, you'd rather have 2.5% of all the oil that's produced on this land than 2.5% of the landowner's share of that 1/8 royalty, bonus, and delay rentals, etc. All right. So what makes a royalty interest? What counts as a royalty? This turns out to be very important because of a common kind of non-participating royalty interest that's granted. So in the case that we just looked at, McSwine versus Musselshell, it was just a straight up 2.5% royalty. But what if instead you had a non-participating royalty interest, and that's what that was there, right? Non-participating. It was granted by the landowner, wasn't related to a lease. That was just one landowner giving to another one. Here's your 2.5% interest. So one common type of non-participating royalty interest we see is one that relates to what the ultimate lease royalty is. So in this example, hypothetical that you have in your book, on page 465, Harris conveys a ranch to the Smiths. But Harris is worried, what if I just gave away a fortune? What if there's a lot of oil and gas on that ranch? And I don't even know what royalty that the Smiths might get. So remember in the Govenda case, if I said I want a 50% of all oil and gas that's produced on that ranch, then probably there would never be any production because no oil and gas company is going to agree to that. But if I said, well, I just want a 16th, a half of the normal royalty. Well, what if this land is really good? And so I could have gotten more. I could have got half of a third or half of a quarter, the lesser royalty that ultimately developed. So Harris says, you know what? Just give me 1/2 of all oil and gas royalty under the terms of any oil and gas lease. So Smiths, whatever you get for eventually developing this this land, I'm going to want half of it, what you get as the royalty. So it's a very common non-participating royalty interest. I want 1/2 or a quarter or a third or whatever of what the landowner's royalty is going to be. Okay, now here's where it gets complicated. The Smiths go ahead, Harris was right, there was oil and gas in this land. The Smiths go ahead and negotiate an oil lease, and it comes with a bonus. Okay, does Harris get that? No, Harris does not get that because remember, that's not the royalty. And what Harris has bargained for is 1/2 of all oil and gas royalty. Bonus is not royalty, so Harris doesn't get half of that. There's a delay rental. Does Harris get that? Again, no, that's not a royalty. Harris doesn't get it. Okay, now here's where it gets complicated. The lease also says that not as royalty, the Smiths get 2% of all production. Does Harris get that? It also includes a royalty. Okay, we know Harris will get part of that. Then the lease also says, additionally, the Smiths are going to get 6% of all production up to $64,000. So they're going to get an extra 6% of production until they get $64,000. Should Harris get half of that? Is that a royalty? And then there's a top up to $2,500 a month. Should Harris get a portion of that too? So which payments is Harris entitled to share? All right. No, Harris doesn't get the bonus and delay rentals. Question, does Harris get that not as royalty, 2% of all production? Well, let's think about that. If I give you a 2% of all production, what is that really? That is a royalty. And the Texas courts have been clear about that. Here in Griffiths versus Taylor, they explain it. It may be that the words bonus and royalty in their broadest concepts and meanings are conflicting and overlapping. On the other hand, when it is necessary that they may be distinguished, there's a narrower concept of the two terms as they are ordinarily and commonly used and understood in the oil and gas industry, in which they do not conflict but are harmonious. In this narrower sense, a reservation or payment of a part or percentage of production, look at that, a reservation or payment of a part or percentage of production under a lease, which is to continue throughout the life of the lease, is regarded as a royalty. So when the Smiths get a lease, they grant a lease, and they say, we get 2% of all production, not as royalty. Is that a royalty or not? That is a royalty. Even if you say it's not as royalty, it's definitely a royalty because it is a share of production throughout the life of the lease. Why do you suppose the Smiths negotiated for a royalty plus not as royalty 2%? Probably because they didn't want to pay to Harris that half that they owed Harris under that non-participating royalty interest. So what the Texas courts are saying is, look, you want to call it technically a bonus. If it looks like a royalty, quacks like a royalty, it's a royalty. So in this narrower sense, a reservation or payment of a part or percentage of production under a lease, which is continued throughout the life of the lease, is regarded as a royalty, and a sum certain to be paid in cash or out of production is regarded as a bonus. So if it's just a payment of money, that's a bonus, even if it's made out of production. And that's crucial for when we go back to the Harris's interest. So as we tick through these, one is, okay, so we know no bonus, no delay rental. We know royalty, yes, that has to be shared with Harris. Not as royalty, hey, whatever you call it, 2% of all production has got to be shared with Harris. There I'm including my sandwich charts for you. You know, look, you can call you can say that like a Pop-Tart is a sandwich, it's the radical sandwich anarchy. But when we talk about a sandwich, we have, some basic ideas in mind. And that when we say a royalty, we have some basic things in mind. So when the landowner grants that non-participating royalty interest that says half of all royalty, if it meets all the definitions of a royalty, we're going to count it. Okay, so Harris gets to keep the royalty plus the not as royalty 2% of all production. Okay, what about these last two? Let's say that those are the hardest, right? A top up of some payment and the 6% of production up to $64,000. I would say that the Texas courts seem to be suggesting that if it's a sum certain, like $64,000, it is going to be counted as basically a bonus, not a royalty, and so therefore would not have to be shared with Harris. But you can see different arguments in different states on some of these questions. So although this is a common non-participating royalty interest, you can see how it can create questions about whether certain things count as a royalty for purposes of this non-participating royalty interest. This we often will throughout course say NPRI, non-participating royalty interest. Okay, now that sum certain that's made out of production, that's called a production payment. As I said, the Texas court seems to suggest it's not a royalty, but what it is it's a share of production or production revenues that you receive until a stated amount has been recovered. So in this Harris and Smith's case, it was a $64,000 amount. Another one example would be you get an extra 16th of the oil and gas produced and saved until 50,000 has been received. Okay, so clear why that looks like a bonus because it's a sum certain. What's the argument for it being a royalty? Well, I guess you'd say that this is like a royalty in that you don't receive any money under it unless there's production. And you're basically getting a share of production, 1/16 free of cost, that depends on whether the well produces enough. The only difference is it cuts off at some point. As I said, it looks like the Texas courts think that that's basically like a bonus, but I could see an argument that it's basically a royalty. Because what if you said until 50 million has been received? Well, then basically, unless this is, you're not going to receive that from one well likely. And so that would suggest that basically you get a full extra 16. So I think at that point, it really would be a royalty. It would just be an extra 16th of production because you'll never hit that cap. So anyway, there can be tough gray areas when you're trying to figure out if a production payment is really a royalty or really a bonus. Now, sometimes it's called an oil payment. The point is that the payment, it is a payment of a certain amount, but it's made out of the production of oil itself. Okay. So some other lease benefits that you sometimes see that you might think about how they fit into this, a net profits interest. So that's a percentage of the net profits. So, unlike the normal royalty where the landowner says, I don't care how much it costs, you just give me a share of what's been produced. In this one, it's a percentage of net profits. So basically, the landowner is receiving, has to receive an accounting of how much it costs to drill, and you get a share of net profits. There's, in my article on the theory of oil and gas, you can see that in theory, this is actually a great interest for landowners to have because it can maximize their total revenue that they receive from the well. The problem is it requires them to like do the accounting of figuring out what the oil and gas company is charging them. So a lot of very sophisticated lessors, often nations, will use something that looks like a net profits interest because because you can actually extract a little bit more money that way. The typical, private landowner doesn't want to be bothered with that accounting. But anyway, you sometimes see it with very sophisticated landowners. Know that this doesn't come with personal liability. So, if the oil and gas company, you get the net profits, but you don't get charged if the oil and gas company loses money. Okay, carried interest is actually a similar, it's a sort of similar benefit. That's a liability less fractional interest in lease profits, but it can be customized so that the oil and gas company can only deduct certain costs, which can be really helpful because if there's some cost that you don't really trust the numbers the oil and gas company is giving you, you can just upfront negotiate it. You don't get to include those. So like some kind of administrative overhead or some shared employee that's used at multiple sites, just say you don't get to charge me that. That's a common interest that's held in another circumstance by non-participating parties, other oil and gas companies that aren't participating in the lease. All right, so let's talk about this Andretta versus West case, which looks at the question of what counts as a royalty. There, the question was if a non-participating royalty interest holder who received 1/4 of royalty, just like we had in that Harris versus Smith case. And the question was whether they should get a share in a compensatory royalty that was paid for violating the implied covenant to protect against drainage. Courts there said, yep, that was a payment that's subsidized for what should have been production. So the oil and gas company should have produced that oil, but instead it was drained off by somebody else. So when the oil and gas company gives you money for the royalty you missed out on, that 1/4 of that royalty goes to that non-participating royalty interest holder. So like the Harris in that scenario. Okay, now let's talk about the question of sometimes there's ambiguous language in a grant that could be a mineral interest or could be a royalty. We'll start with the clear case and then we'll look at some complicated ones. So Barker versus Levy. Levy was given 1/160th part of all oil, gas, petroleum, sulfur, and all other minerals that may be produced and saved. Okay, so the question is this a mineral interest or is it a royalty interest, right? Is it 1/160th of all the oil and gas that's under this property, or is it 1/160th of everything that was produced? And I think it's probably reasonably clear from this language that it's of everything that was produced, right? It's what was produced and saved. As the court says, he didn't say in and under, didn't say the 160th of all the oil and gas in and under the land. Now, one thing, again, remember the McSwine case. As Levy, would you rather have the mineral interest here or the royalty? You'd rather have the royalty because the royalty means you get 1/160th of everything produced. Otherwise, you just get 1/160th of the landowner's royalty, which might be just 1/8. So you get 1/160th of 1/8. You'd rather just have 1/160th of everything produced. So Levy gets what he wants in this circumstance. All right. So here's some of the most common mineral interest and royalty language that you'll see. Mineral interest. So this is what the court didn't see in Barker versus Levy. Very common language would be that you receive a percentage of the oil, gas, and other minerals in, under, and that may be produced from the land. Okay, the court said you didn't say in and under, so the common language is in and under, and that may be produced. For royalty interest, most common language is the one you do see in Barker versus Levy. Percentage of the oil and gas and other minerals that may be produced and saved from said land. Okay, now note, it's a little bit confusing that produced appears in both definitions. Why is that? Why is it in the mineral interest? Because isn't it basically in the mineral interest supposed to be the oil and gas that's in the land, in and under? That's why we often look for that language, in and under. The problem is, remember the rule of capture. If you own the mineral interest, you own the oil and gas in the land, at least here in Texas, but you also own whatever can be produced from that land. Because if you drill a well and you have the mineral interest, you can pull up oil that was actually originally on your neighbor's land and that's now produced from your land. So that's why produced appears in both, which can be a little bit confusing, but I focus on that in and under. And then if you see the saved, that's a pretty good sign that you're talking about a royalty interest. But as we'll see, there's no magic language. I mean, the real question is it like talking about the oil and gas in the ground, or is it talking about what comes out of the top of the well? Okay. Now, some states, there's some minority views in other states that can be quite complicated. In West Virginia, they say, well, there's this rule that if you grant profits to land, that can be actually construed to be the land itself. So they say that even if you said royalty, that could mean a mineral interest. Colorado actually tried to kind of force everything to be mineral interest because they said we don't even want non-participating royalty interests until they were legalized by statute in 1991. As we go through future cases on all the problems that non-participating royalty interests can create, you will see maybe why the courts didn't like them. But I should say, they are a very useful financially structure. And so I believe they're here to stay, including in Colorado. Now, the Oklahoma cases are confusing. Basically, what they seem to say, they use kind of precise language. One says, well, do we have a definite royalty? And a definite royalty is like what we had in that McSwine case, where it's just like a 1/16th royalty, has nothing to do, it doesn't have anything to do with whether the land has an oil and gas lease. That just says I get a certain percentage of all production, like the 2.5%. But then they talk about an indefinite royalty, where like that Harrison Smith hypo that we did, it's 1/3 of royalty. So that of word is so crucial because it says when you add that of, all of a sudden it's not 1/3 of all production, it's 1/3 of the royalties. And so that Oklahoma says is a mineral interest because basically it's like you had a 1/3 mineral interest. If you had a 1/3 mineral interest, you would get 1/3 of the royalties. And so they say it's just a mineral interest unless that NPRI, that non-participating royalty interest, was created when the land was already leased. And then they say, oh, well, look, if there was a 1/8 royalty under an existing lease and you granted to somebody, oh, you get 1/3 of the royalties on that land, then we know, oh, basically what you meant was a 1/24th royalty. Why you didn't say that, I don't know. But that is, that's the way Oklahoma looks at it, which is a little bit confusing. As we'll see, it can be confusing enough just in Texas. So in Texas, let's look at some of the reasons that there is ambiguity sometimes if it's a mineral interest versus a royalty. One of the common reasons is that the grant or reservation language just doesn't make clear whether it's a mineral interest or a royalty interest. And often this happens because it mixes language used to describe one interest with that of the other, or it starts customizing and says, well, it's a royalty interest, which is just the right to receive a percentage of oil, but we're going to add some other rights. Maybe we want to give it a little bit of bonus. Or on the other hand, maybe it's a mineral interest, which would include the right to lease and the delay rentals and everything, but maybe we'll take some of those away. And by mixing them, it can become unclear whether what was really intended was a mineral interest or a royalty. And what we'll see is sometimes that makes a huge difference for what the grantee and grantor receive. So let's talk about this French versus Chevron case, which is in page 478 in your book. That case, the instrument said it was giving an undivided 1/656 interest in all of the oil, gas, and other minerals in, under, and that may be produced. Okay, so as you look at that language, what does that say to you? Mineral interest or royalty? That looks like a mineral interest, right? It says in and under, and it may be produced. That's classic mineral interest language. Okay, here's the problem. This conveyance is a royalty interest only, and the grantee shall never have any interest in the delay or other rentals or any revenues or monies received from the leasing or the renewal or extension of any lease, and that grantee shall never have any control over the leasing of said lands. Confusing, right? Because if it was a 1/656th mineral interest, that would come with the right to lease 1/656th of the property. That would come with 1/656 of the delay rentals, shut-in royalties, etc. And they say no, it's not that. In fact, it's a royalty interest only. Okay, what does that mean? Well, the court says this means that they only get the, as they would with a mineral interest, 1/656th of the lease royalty. Okay. By the way, good reminder of how much money could be involved in oil and gas cases. They litigate all the way to the Texas Supreme Court the question of whether it's 1/656th of all production or 1/656th of the lease royalty. So that, that is big money on the line, even for small fractions. So the court says the deed basically conveys a royalty. And the way it does it is it gave a 1/656th mineral interest, but then it says, but then it struck out everything else by saying, you don't get the delay rentals. You don't have any right to lease the land. You don't have any control over leasing. And so basically it said, it made a royalty by first giving you the 1/656 share of the lease royalty of all the revenues that the lessor landowner would receive. And then it took away all the extra things that you get with a mineral interest, like a share of the delay rentals, like a share in the right to lease it. Okay. Now it gets even more confusing if you look at Watkins versus Slaughter in this Texas 1945 case. In that case, the grantor reserved title to a 1/16th interest in and to all the oil and gas and other minerals in and under and may be produced. Okay, so again, 1/16th mineral interest, you might think, okay? Because it says in and under. Without the right to lease, bonus, or rentals, and it said that the shall receive the royalty retained only from actual production. Okay, so again, you might think, okay, again, you gave the mineral interest, but then maybe you strip the other stuff out. What the court here says is, no. This is a 1/16th royalty. Now, keep in mind, that 1/16th royalty says not 1/16th of royalty, which would just be 1/16th of whatever the landowner's share is, maybe an eighth. This is a straight up 1/16th royalty. Okay, now if you look at those two decisions, the language in each one, they don't look that different, but the court here clearly believed that a bigger share was owed. So if we look at this as like, there's three possibilities. So one would be a 1/16th of royalty. One would be a 1/16th mineral interest, and then one would be a 1/16th royalty. Okay, which ones of these would you want as the owner of the non-participating royalty interest? Okay, the worst one is 1/16th of royalty. Okay, because that just gives you 1/16th share of whatever the royalty ends up being. 1/16th mineral interest is only a little bit better. It gives you the right to lease 1/16th of the property. So maybe that's worth a little bit, some control, although not much because somebody else owns 15/16ths of the property. But it also gives you 1/16th of the bonus, 1/16th of the delay rentals. So it's worth a little bit more. Now, what's the best one here? By far, the best one is 1/16 royalty, because that says you don't just get a 1/16 of the landowner share, you get a 1/16 of everything that's produced. And that's what the court says it gets here. So in both these cases, if we go back to French versus Chevron, the court says basically a royalty was created. But in French versus Chevron, it's a small royalty, just 1/656 of the lease royalty. That's like as in the, if we went in Watkins versus Slaughter and just said, oh, you only get 1/16 of the royalty. But in Watkins versus Slaughter, it says, okay, no, you actually get this bigger share, 1/16 of all production. Okay, there's another case in your book that the court has done that more recently. So those cases remain in tension. I would do your best to try and make sense of what the difference is. Maybe, the difference is that in the French versus Chevron case, it sounds like the instrument is trying to make the interest sound small. It says, look, it's a royalty interest only. You're taking it out. Whereas in Watkins versus Slaughter, it says from actual production, which makes it almost sound like a full royalty. Okay. Now, can you add rights to a royalty? So in other words, a royalty normally just comes with it's just a share of production. It's just basically money or oil. So for example, would a deed granting 1/16 royalty on oil and gas and the right of ingress and egress mean that the parties really had intended a mineral interest, even though they said royalty? Well, it really depends on whether royalty just has one meaning. The Texas courts would say, no, this is still a royalty. You just gave the right, maybe the royalty owner wants to be able to check in on the oil and gas production. Okay, in Oklahoma, it's Anderson versus Mayberry case. In that case, it was accepted and reserved. A grantor had accepted and reserved onto the grantors an undivided 1/2 interest in and to all the oil and gas and other minerals in and under, and that may be produced from said property, and the said interest so reserved shall be non-participating in bonus and rental rights. Okay, so what does this sound like? Again, it sounds like a half mineral interest, but you'd think they'd have the right to lease half of the property. And that was what was litigated in this case. Did they have the right to lease the property? The court says, well, no, because they waived their rights to the bonus and rental rights, which are the other big parts of the lease. So what was really, so because they were non-participating, obviously they weren't supposed to be able to negotiate the lease. So they implicitly waived their right to execute the leases. So do a simple calculation and say they're basically this half mineral interest has been stripped of everything but half of royalty. So they get 1/2 of royalty. The lease royalty was 3/16. So if you all remember, when you take a half of another fraction, you multiply them, just multiply the tops, multiply the bottoms, and so you get 3 30-seconds of production. Or you could just double the denominator. You'll get really used to doing these fractions as we continue to go through some of these conveyance cases. So look forward to that.